Good afternoon again, everyone. It's now 3 minutes past 2, so I think we should just get started. If people are going to join, they will join as the webinar continues. Welcome to preparing for the Black Swan event series, part 1. This session is hosted by BDO Advisory Services, in particular the BDO Cyber Lab. My name is Shannon DuPont, and I am the Associate Director within the BDO Cyber Lab. Within Cyber Lab, we're responsible for providing assurance and advisory services across the cyber landscape with things such as cyber risk assessments, cyber incident readiness reviews, policies and procedures, ransomware readiness, penetration testing and vulnerability assessments, phishing simulations, governance, risk and compliance, and many other areas to assist organizations with, either improving their risk posture or general audit requirements. Cybersecurity refers to technologies and processes designed to protect information assets by addressing threats to information processed, stored, and transferred through the network. Now, this month is an essential month for cybersecurity and focuses on cyber awareness. Our Black Swan series aims to raise awareness and share knowledge with businesses about cyber risks, legal requirements and compliance, and implementation of technology control measures to protect your information assets against these threats. We will start by sharing insights on the Cyber Crimes Act and Protection of Personal Information Act, followed up by a cyber awareness enablement through Meeting the Hacker webinar, then insights into technology to protect network parameters to the cloud, and lastly, discuss the automation of vulnerability management in the organizations. So this will be a 4-part series with 1 webinar per week throughout this month, this being the first one. And the aim of this particular one is to unpack the Cyber Crimes Act and the Protection of Personal Information Act, to address obligations, expectations, and offenses concerning information security breaches or incidents. So hopefully we can add to your knowledge base, widen the understanding of these acts. If not, then let it be a refresher to have you thinking about them again. So before we proceed, I'd just like to go through a few logistics. The webinar should be 40 to 45 minutes, after which we can take questions. With your consent, this webinar is recorded and will be made available through our website. So if you're uncomfortable with recording, please do let us know. You're welcome to share your questions. You can just drop them in the chat, and then we'll look at them throughout the webinar, and then, as I said, reserve some time at the end to go through those questions so that our speaker can respond. Speaking of speakers, our speaker is Lucian Pierce. He's a managing director at POPIA Pierce Masitela Attorneys, PPM. Lucian focuses on the commercial and regulatory aspects of telecommunications, media, technology. He covers matters such as commercial transaction, satellite frequency spectrum license applications. If you don't know what that means, don't feel bad, because I have no idea what that is either. Information security, data protection, and fintech. Lucian has represented and represents organizations such as ICASA, China Telecoms, Prime Media, State Information Technology Agency, Anglo American, and a multinational cloud services provider on ICT and information security matters. He also has a number of articles, publications, and presentations, such as co-authoring cyber law at SA, drafting SA data protection legislation, and he also regularly presents at seminars and workshops. He's clearly an expert on these subjects and very well positioned to speak on these today. So thank you for making yourself available for this, Lucian. Thank you to the attendees for attending. Lucian, the floor is yours. Please go ahead.
Good afternoon, Shannon. Thank you for the invitation to you and the team at BDO. I'm hoping that by now, after 2 years of COVID and a year after that, you can hear me and I don't have to say, am I on mute? If you can just confirm that you can hear me and see me, that would be great.
100%, loud and clear.
Excellent, that's great. Okay, I'm going to share my presentation. Just bring it up onto the screen if you just give me a second. Okay, so today we're going to be talking about POPIA and the Cybercrimes Act. So if you've all been good and compliant people and law-abiding, by now you would have made sure that your POPIA compliance process is in place within your organizations. If you haven't, then you are a little naughty, and it's quite possible that if things go wrong, and even if things don't go wrong, the information regulator might come knocking on your door. So today we're hoping to give you an idea of what happens or what will happen if things do go wrong. Whether you've been naughty or whether it's been the inevitable hack that most of us are going to suffer, I'm going to try and give you some guidance through how to deal with that to make sure that your interactions with the information regulator go a lot more smoothly than they have with some others. So on to our next slide. Great. So today we are going to be discussing, as I mentioned, both the Cybercrimes Act and POPIA. We're going to focus on the enforcement provisions of POPIA, simply because, as I said, I've assumed that all of you have been pretty good and pretty compliant and you have your processes in place. If you know how the enforcement process works, so when this Black Swan event that we're going to be talking about over the next few weeks, when that occurs, you're going to have a much smoother process, better interactions with the information regulator, and know how to minimize any antagonism that sometimes arises when you might be dealing with the regulator. We'll give you a brief overview of the South African Cybercrimes Act, which is fairly recent, and give you insight into how it works. What we also want to do is we're going to give you an overview, a very brief overview of the draft South African Police Service Standard Operating Procedures. Now, why would we bring that in? The reality is, if you're going to have a breach, it's not only going to be the information regulator who is dealing with you, overseeing, investigating if necessary, but you might need to also take action and report this to the South African Police Services, if it's, of course, serious enough to warrant that. Now, you would want to know how that process is going to work. You might have advisors on board. You might have forensics people who are going to need to work with SAPS as well. So if you have an idea of what they're going to expect and what they're going to be doing, that process in itself will also operate a lot more smoothly. So we'll give you an overview of that. What's important to emphasize is that that standard operating procedure was a draft document that was put out for public comment a little earlier this year. Comments were submitted and closed about a month ago. And of course, what happens now is the comments and contributions and submissions that the public have made will be taken into account, and that the draft document will be finalized and it will be published as an actual legal document. I spoke about the firm a little earlier, mentioned that I'm vastly outnumbered. There are two of us, and the rest of the firm is made up of outstanding women technology lawyers, as you can see from that picture. So if you look at that slide, you see that it happens to the best of them. You're going to see Marriott, Nedbank, not directly. The reason I've put the Nedbank example there is because it might not be you that it happens to, but it might be one of your subcontractors, someone who you've outsourced work to. POPIA refers to those people as operators. You, of course, are the responsible party. The name says it all. You are responsible, and ultimately you will take the blame for what goes wrong, even if it is one of your operators or subcontractors. I might say at this point, in case I forget to mention it at the end or the appropriate section, but the interesting thing about POPIA is that it is a law that essentially has what we call strict liability. So if things go wrong, even if it's somebody else's fault, for example, the Nedbank issue, where one of their marketing service providers had a breach, in that case, as much as Nedbank systems might have been bulletproof, secure, they still have to take responsibility for the fact that their subcontractors or their service provider systems were in place. And that is why POPIA has a section between sections 19 and 22 that talk to security, confidentiality, integrity of information, and also how you are required to ensure that all your service providers also comply with POPIA. So we don't want to see you as one of these headlines, and we hope that you've done what is necessary over the past year, because many of you might know that POPIA has been in place for about a year now. In fact, we're going to talk on the next slide about what the regulator has found during the course of the past year. So hopefully you've done everything that is required and that you're in a good position from a compliance perspective. So it's about a year, it's about 13 or 14 months since POPIA came into effect. And what has the regulator found in the past year? So we've seen in, I would say, the past 4 or 5 months, an assertion, a confidence growth from the information regulator. We've seen a lot more happening in terms of the regulator investigating perpetrators or people who've broken POPIA's requirements, if I could put it that way. About a month back, in fact, it might have been 2 months back, POPIA, the information regulator, held a public consultation session, an investigation, almost like an inquiry. In that instance, it was investigating failures by a company or an organization in the music industry to provide information to artists about royalties. So we've seen the information regulator really assert itself. Since the 1st of July, they've had 330 security compromises reported. Now, for me, I smell a rat there, because just from our side in representing clients, we've submitted quite a few. I like to advise my clients to be compliant. POPIA is unequivocal that when a breach occurs, there is an obligation to report it. I was on a webinar with the information regulator about a month ago, and one of the suggestions that was made, in fact, I put it to the regulator, is that they need to have something in place that is very similar to GDPR, a kind of a threshold that will allow people to judge whether to report or not. Now, when I look at 330 security compromises, and I'm sure that the BDO CyberLab team will probably agree, I suspect that in South Africa there have been far more than 330 security compromises. And the reality is all of those should have been reported to the information regulator. Now, I'll come back to that a little later, because other regulators in other jurisdictions, and I suspect our information regulator as well, is going to take a very hard line on the failure to report compromises. The reason for that being that whoever has been the victim in such a compromise, you know, their personal information has been taken. It could be used for malicious purposes, and they have the right to know and be on guard that their information is out there. And if they're not on guard, it's more likely that they will fall for any confidence tricksters, phishing attacks, etc., a lot more easily. So on that note, please make sure that you are complying with POPIA as far as reporting is concerned. Now, you'll see from the next bullet point there that quite a few high-level investigations have been initiated. WhatsApp, when it went through the changes to its terms and conditions, the information regulator wasn't too pleased about that and initiated an investigation in that regard. Similarly, TransUnion, a little earlier this year, had a breach, and that is also being investigated. Embarrassingly, and this was a bit of a strange arrangement for those of you that follow or are in the know as far as POPIA is concerned, the Department of Justice had a major breach late last year. Now, what is interesting is that the information regulator is at that particular point in time was also hosted on the same website or platform as the Department of Justice. So there was a bit of a debate in jest as to whether the information regulator had to report itself about the breach that had occurred to it. More recently, and on a more serious note, the South African police services have been investigated. Their investigation, I suspect, is going to result in some serious penalties for them. It relates to a very tragic incident that happened about 2 or 3 months ago, where a film crew with women who were filming a music video were attacked, accosted, and sexually assaulted. Now, in that case, the South African Police Service were investigating, and for some strange reason, put all the details of the survivors, the rape survivors, onto this WhatsApp group, circulated it with their names, addresses, etc., and that was leaked and became public. Now, the information regulator approached SAPS, asked them for information. They did provide some, but were almost treated the information regulator with disdain. And as a result of that, the information regulator has initiated an investigation and has also issued summons against the South African Police Services. If there's one investigation that I think is going to result in major penalties, it is this one. I think the lesson there is don't be obstructive. Don't treat the information regulator with disdain. Cooperate, but don't be supine. You know your rights, and when things go wrong, ensure that everything follows the act strictly. You'll see that 700 complaints, mostly related to direct marketing, have been filed over the course of the past year. Now, if anybody can, let me see if I can see the screen. Actually, no, I won't look at it. If you have subscribed to those internet florist people represented by Harold, and if you've ever tried to unsubscribe from the emails, whether they be daily or weekly, that Harold sends, that is a mission. Now, already, I do know, if you just do the hashtag those guys, you'll see that quite a few complaints have been filed. The problem with that, and again, take note from this, is that it is like trying to hike up Mount Everest, trying to unsubscribe from that service. And the contravention there, in my view, is the guidelines that the information regulator has issued regarding subscriptions and mailing lists, etc. It says it's got to be very easy for you to get off that mailing list. And I tell you, I have failed time and time again. Now, you might also not know, but the information regulator has a dual role. That role is not only to look after the Protection of Personal Information Act, POPIA, but it is also to oversee the administration and compliance with PIA, which is the Promotion of Access to Information Act. One act deals with the protection of information, the other deals with access to information, i.e. transparency. It, as I mentioned earlier, initiated an investigation against Reza, which is in the music industry, and that related to access to royalties by various artists. Now, given that we've seen that the information regulator is busy, also given my view that not enough reports are happening of security compromises, and also given the fact that in other jurisdictions, and in our jurisdiction as well, the information regulator takes the failure to report compromises very seriously. An example of that, and this is somebody who literally slipped through the nets, if I could call it that. Experian had a major breach early in 2021 before POPIA became effective. So that basically wasn't subject to POPIA because POPIA came into effect in July 2021. Now, what the information regulator said was, even though it didn't have jurisdiction or the ability to investigate Experian, it was quite incensed. If you go and look at the information regulator's website, it has various press releases and comments that it puts out on investigations and issues that have arisen. And the tone that you will see when it discusses Experian is quite scathing, might be too much, too hard of a word, but it definitely expresses its displeasure when they speak about Experian. On the other hand, if you look at a company like Liberty, and you read the comments from the information regulator in that regard, it is much more glowing. The reason for that is obvious in that right from the very beginning, Liberty reported their breach very quickly, even though they weren't obliged to, because their incident also happened before POPIA became effective. They reported it very quickly. They updated everyone very quickly. They liaised with the information regulator and had joint briefings on that, as opposed to Experian, which took a while. And that was part of the reason why the information regulator was so upset. Experian took a while to report that compromise. So learn from that. And if you do, you'll find that your dealings with the information regulator will be a lot smoother, and you will potentially, if things go wrong, come out with less of a fine or perhaps even just a slap on the hand. Now, what I've done here is I'm going to focus on Chapter 10, which is the enforcement chapter. And it's quite a lengthy chapter, from 73 to 99, so quite a few sections. I've loosely broken it down into three phases, if I could call it that the enforcement process will occur. The first, of course, is where the investigation, where the process is initiated. I've called that the complaints or investigations phase. The next one is the investigation proceedings phase, where the information regulator really digs in and does what is necessary to formulate almost a preliminary view about whether this compromise it might be investigating should be taken further. The last bit of the enforcement chapter is what I've called, and the Act also calls, the assessment and enforcement phase. And this is where, if the matter is worthy of further processes, another body called the Enforcement Committee gets involved, and we'll get into that shortly. Right. So as far as the process of enforcement is concerned, it actually happens in one of two ways: the way that investigations occur or the way that the information regulator gets involved. It's important to remember this. Don't think that you actually have to have a data subject, that's the individual or somebody whose data you're processing. Don't think that only they can start the process by complaining. The reality is that POPIA, the Act says that the information regulator can also unilaterally investigate contraventions of POPIA. So literally, if it comes to its notice that somebody might be on the wrong side of the law, it can start an investigation itself. I won't go through each of these points in detail, and I'll just give you a broad overview of what the process entails. So as far as complaints are concerned, they must be in writing. Somebody cannot just call the information regulator and say, hey, I have a problem. It's got to be submitted in writing. What the information regulator then does is it initiates the process, considers the complaint, and determines whether this is something that falls within its area. It may in fact decide that this is not something that it is obliged to deal with, and it may take no action, or it might refer the complaint to the more appropriate regulatory body. It could well be something that ICASA needs to deal with. It could be something that the National Consumer Commission might need to deal with. So it will assess it at that point, and it will decide whether to proceed. So at that point, if it does decide that it's something within its jurisdiction, what it then does is it starts pre-investigation proceedings. And it's almost like an information gathering exercise. It notifies the complainant that it is going to proceed. It notifies you the responsible party that is the subject of the complaint that a complaint has been filed, and it might ask you at that point to submit a response to the complaint. The intention being to determine whether this is something actually that could be settled a lot more easily than following the entire enforcement process. So at that point, it might assess your response and say, look, Mr. or Ms. Data subject, this is what the responsible party has said. We don't think this is something that merits investigation, so we're not going to take it further. Or the Act provides for the information regulator to almost act as a mediator to procure the settlement of a complaint. So the idea there being that the information regulator doesn't waste its resources pursuing something right to the end when in fact it could be dealt with in a way that both parties would be satisfied with. So that's the early stage, the pre-investigation stage of the enforcement process. And this is where we get into a little more, the more serious stage of the process. Now, it might well be that the information regulator decides that it needs to get more information from the data, from the responsible party, you being the one who was processing information. And normally it will do a simple request. It will write to you and say, please, we need more information on this, that, or the other. Of course, if you play hardball, which is why I was saying, weigh up whether the approach that you want to take in dealing with the information regulator, because it could have certain consequences. Now, if you tell the information regulator to go and jump in the lake when it asks for certain information, it might then step up a notch and it would issue warrants. And the warrants that the information regulator issues are on par with warrants that are issued out of a high court. So they hold a lot of power, and to ignore them, you ignore it at your own peril. What's interesting is that there is a process that is followed to obtain the warrant. So now you've decided you're going to play hardball and not provide information and not allow the information regulator into your premises. The information regulator then says, hey, I'm going to apply for a warrant, and this is the process I'm going to follow. And the Act is pretty, it promotes the fair administration of justice, because what it does is it says you're allowed to actually go there when the warrant is being applied for and to oppose it and to give reasons why you think this warrant should not be issued. For those of you who don't know, and of course I always assume that everyone is a lawyer, a warrant is a document that allows the information regulator to go into your premises and to search those areas that the warrant authorizes it to. So the warrant might say, search all cupboards, search all filing cabinets, and search the responsible party's servers. What's important about a warrant is that the information regulator or anyone acting on it cannot go beyond what is set out there. So as I mentioned, and of course I strayed into the requirements for issuing a warrant, those are some of the requirements that are required. Now, when the information regulator issues the warrant, again, there's a respect for your privacy in that it must occur at a reasonable time. So they can't come knocking at 2 a.m. to enter your premises. Of course, you can object if they come there at a strange time, especially if it is not in the circumstances I'm going to talk about next. So what can happen is that if it's obvious that by getting a warrant and coming and knocking on your door and saying, I'm the information regulator and I want to gain entry, if that's going to defeat the object of the exercise, then what the information regulator can do is obtain a warrant in circumstances where you are not informed of this, and they literally come there and conduct what we would call a dawn raid. Many of you who are in compliance or might be in competition law would know what the term means. It's literally where you're still bleary-eyed and they walk through your doors to come and conduct their search. Now, certain information, importantly for you, cannot be included in the information that they collect. So privileged information, i.e. communications between yourself and your legal advisors, and it gets into pretty technical aspects here, but generally communications between you and your advisors where you're getting advice on certain aspects, those may not be taken, and you can object to it being taken. There are processes that are followed where quite literally that bit of information that you're objecting to or which you claim is privileged is literally put in a bubble, if you want to call it that, and then a process takes place where the information regulator and yourself argue in the High Court about whether that information is indeed privileged or not. So that's an important consideration. Importantly also, you have the right to call your lawyer as soon as this process is occurring. So whether it's a warrant, which goes through the normal course and they come between the hours of 8 or 5, and where dawn raids occur, they must give you an opportunity to get legal representation to come and look at that warrant and determine whether it is has been properly issued. And don't be afraid to scrutinize it, very much like the summonses that some of you might get where you've had a compromise and the information regulator wants more information from you. Look at the summons, look at the warrant, look at it in the context of all the steps that POPIA sets out that a warrant is required to fulfill, because it's quite possible that somebody might have missed a step and that warrant or that summons is invalid. It's not unusual for it to happen. There are cases that have gone to the High Court where, for example, the public protector had some of her warrants set aside, some subpoenas and summonses set aside because they fell outside of her power. So we have a term in law called ultra vires, which means outside of your power. And in that case, the public protector had issued a request for certain documents which were not within her domain to investigate. And that essentially is the process that is followed when you are being raided or when a warrant is issued to come and search for information. Now, to avoid that process, if it is at all possible, try and adopt an amicable approach with the information regulator. Don't be a walkover, but if you can, rather avoid this process of warrants being issued because it can disrupt your business and it's just very uncomfortable. Then on to the next phase. So if the information regulator has now gathered all the information that it requires, whether it's by way of requesting it from you or whether it's by way of a warrant, it then assesses all the information and determines whether this is something that needs to go further. It might require more information after that and issues an information notice. It tells the complainant what has happened in the process. It also gives you more information on what its thinking is and what it might still require from you. And that is, of course, where you're informed of the assessment result. Now, the information regulator has a body, and a separate independent body almost called the enforcement committee. It takes all the information that it's gathered, it takes the assessment and it hands it over to the enforcement committee. Now, I had said earlier that it's clear that the information regulator is starting to assert itself. The reason I say so is because they also about a month ago, you'll notice everything has happened in the past 3 or 4 months, and appointed their enforcement committee. This is 14 highly skilled, highly qualified people who will assess the assessment reports and determine how the information regulator should proceed. If the enforcement committee says this is something that merits further investigation and prosecution, what the information regulator then does is it issues something called an enforcement notice. The enforcement notice is essentially an order that prescribes what you are required to do to remedy the issue that the information regulator was investigating. They might say, you know, you need to strengthen your security, or a whole lot of different things that, from a security perspective, BDO's Cyber Lab might be better qualified to speak about. What's important to remember also as part of this process is that the information regulator is allowed to undertake civil litigation on behalf of the data subject or data subjects. So it can literally bring a class action suit on behalf of people whose data might have been compromised as a result of your your negligence or even the negligence of one of your service providers. And that process also entails many steps. It entails the recovery of costs by the information regulator, and it entails the sort of proportionate distribution of any award to data subjects, particularly where there's more than one of them. You might, if you've been following developments in Australia, you would have seen that Optus had a major breach during the course of last week. And it was barely a day after that two major public interest law firms announced that they were investigating and inviting interested parties in Australia to join or put their names forward to be part of class action suits against Optus. And very quickly as well, you would have seen Singtel, which is Optus's parent company, appointed some very heavy-hitting lawyers at the early stage to start advising it not only in its dealings with the regulator there, but also with regard to the potential class action suits that are going to follow. So not because I'm looking for work, but it is important that you get your lawyers involved very early on. You might not have had anyone involved before that, but one of the benefits, if I can put it that way, of getting your lawyers involved is that any investigation that you do internally, perhaps you might get forensic investigators in, that process is what we would call privileged, again, subject to certain compliance, or you need to comply with certain minimum requirements, which I'll explain in a minute. But if you brief your lawyers to brief third parties to do the investigation, there's a strong likelihood that that information will be privileged. And if it's a really terrible finding from your forensics people, you won't need to hand it over to the information regulator to dig an even deeper hole for you. Now, why I said that there are certain, it's a pretty tricky area, is there's a case before the Supreme Court of Appeal at the moment where it's in the Steinhoff matter, where its lawyers had briefed a company, an audit company, to do an investigation. And the report was provided to the lawyers. And what then happened was some journalists wanted to get sight of that report, and Steinhoff and its lawyer said, no, this is privileged. And the court said, no, that report must be disclosed because you didn't follow certain steps to ensure that that information would be privileged, i.e., it's legally privileged and nobody else could use it. But that's a whole webinar in itself. So I'll move on from there. So please try and be open and cooperative. We've seen already the attitude that the information regulator takes when it investigates. But at the same time, don't compromise on your rights. Make sure that you know this section, or your lawyers know this Chapter 10 well, so that your rights aren't infringed. It's a very important one, which is why I focused on this today. You're all going to have your black swan events, and if you're better prepared from a legal and compliance perspective, you will handle that process a lot more smoothly. Your interactions with the regulator are likely to be less strained, and ultimately, you might not get a punitive fine because of behavior that might not have been, or behavior that might have been frowned upon. So pay attention to Chapter 10. And that is the overview of what to do and what to expect when things go wrong under POPIA. I'm now going to move over to the Cybercrimes Act. How much time do we, Shannon, how much time do I have left, if I may ask? Everything is all over the place.
Yeah, look, it's 2:48 now. We've got 12 minutes left. I think you can get through as far as you can. I'll just remind you maybe when there's a few minutes left.
I've got two slides left in any event, so it won't take too long. So let's move on. I probably need another 6 minutes, which will leave us with some time for coffee afterwards. Great. Okay, so the Cybercrimes Act is a relatively new act. It has a long history and took quite a number of years to be passed into law. Not as long as POPIA. If any of you are involved in the sector, you will know that POPIA, or POPI as some people call it, the information regulator insists on it being called POPIA or POPIA because there's an A, it's an act. You'll know that POPIA actually started in 2003 as a discussion paper that was issued by one of the legal bodies in government. And from 2003, it took 10 years, 2013, for it to actually become a law that became fully effective. Not fully effective, actually, just a law in the country. Now, if you're a lawyer or if you have a bit of legal knowledge, you know that an act can be passed, but its effectiveness can be delayed. So, of course, POPIA, as much as it became a law in 2013, it was only another 7 or so years later that it actually became effective. So when we look at the Cybercrimes Act, its trajectory was a lot shorter. It was actually made up of two pieces of legislation, sort of that were mixed into one. Cybersecurity and Cybercrimes Act is what it was called, but they decided to split it into two because part of the reason we need a Cybercrimes Act very quickly is South Africa is trying to position itself as an information economy. And you can't position yourself as an information economy, in other words, to invite people like Google, as we've seen in the past 2 days, and Microsoft and Amazon to set up data centers and operate from here, unless we have the laws in place to be able to prosecute crime. Now, or cybercrime, let me put it that way. And you'll see that this is an act that is specifically focused on cybercrime. It seeks to criminalize certain data messages. Now, you might think, well, what's a data message? It's essentially something that is sent electronically, tweeting something, emailing something, posting something on a website. All of that is contemplated within the Cybercrimes Act. And it goes further because it allows for interim protection. In other words, if somebody's put something about you online and it's in the public domain, you are able to go and seek very quick interim protection while you fight out with that person as to whether they can put it there or not. You know, we've got very strong freedom of expression laws, and somebody might say, well, that painting, I don't know if how old the average crowd is here or attendee is here, but about 15 or 16 years ago, there was a painting called The Spear of Jacob Zuma that caused so much controversy. And the argument there was its freedom of expression, and the other was that it infringed his dignity and privacy. And that fight went on for a while. So this sort of provision allows you to get interim protection while fights like that are sorted out. What's also important is, given that hackers could be sitting, from Miami to Moscow and Milan in between, the Act provides for international cooperation between different law enforcement entities in different countries. It's quite easy to sit in Moscow and to attack a server here in Johannesburg. It also protects against malicious images or intimate images. And this gives very, very specific powers and rights to anyone who's been infringed in that regard. And it's very broad. It covers even crimes that are not cyber specific, but rely on IT aspects to commit the crime. So it might well be that somebody commits a heist, but has used tracking technology to perpetrate the crime. In that instance, they can still be prosecuted under normal criminal laws, but can also be charged in terms of the Cybercrimes Act. So they have the entire book thrown at them. What's also significant is that this act places certain obligations on financial services providers and telecommunications providers to report within 72 hours certain contraventions or hacks that they've experienced, or if their systems are being used for cybercrime. So it's quite a wide-ranging law. It also provides for capacitation, that's such a consultant word, it also provides for strengthening of the law enforcement sector. In other words, prosecutors, South African police services, and the security agencies must have training on ICT. The Act even says that a police official who might be involved in investigating cybercrime needs to have the basic knowledge to effect certain seizures, which means attaching certain evidence themselves if they're unable to get an expert on board to assist them with that. So it's very wide-ranging. It talks about setting up universities and colleges to empower the law enforcement community. Let's hope that happens. Now, what the Act also says is, given that this is such a specialized area, it says that within a year of the Cybercrimes Act having become fully effective, so it will be a year in about 6 months' time or so, it needs to ensure that it has standard operating procedures for the South African Police Service. Why? Well, all this data can have very sensitive information in it. If somebody simply goes and takes a computer, there might be intimate images of you and your partner. There might be other information that is particularly sensitive, whether it be health data. And these standard operating procedures deal with aspects like that. It deals with jurisdiction, and it talks about how the South African Police Service and the extent of the powers of their investigation or their jurisdiction to investigate. It talks about being able to call on in law enforcement in other jurisdictions to assist. What it then talks about, and this is the one that is probably most important for you if you have been the victim of a cyber attack, or if you're accused of being the perpetrator of an attack. It provides general guidelines on investigation, search, access, and seizure of an article. Now, you might ask, well, what is an article? Well, the Act it defines an article basically as any electronic device or any software or something similar that is used to commit a crime. And it just defines it as an article. So when we mention article in the Cybercrimes Act, or in the standard operating procedure, that is what we're talking about. We're a little over time now, so I'm just going to basically go through each of the bullet points there. On the right, you'll see the first page of that document. Now, as I mentioned, it's been submitted already. Public comment is closed. So it's likely that this document might be published in the Gazette in its final form, and I would encourage you to look at that as soon as it is published, particularly if you're involved in forensics or auditing or private investigation. It will be helpful because what this talks about is it also sets out how the South African Police Service can engage with the private sector and bring on board experts from the private sector. And it sets out exactly what how that relationship should work to make sure that I suppose the accused person can't attack the investigation and the prosecution based on non-compliance with certain steps. What's important is that it's very specific about how pornographic images of children are to be dealt with and who may look at it during the course of the investigation. It also talks about how you would procure data and information that is held by third parties. So, for example, if the information is in a data center, it talks about how you go about securing that as the South African Police Service and any private sector experts that are brought on board. Evidence, for those of you who are in forensics and have conducted investigations, it specifies how digital and data message evidence is to be dealt with. It talks about how you store it. It talks about keeping it away from magnets. It talks about not putting stickers on it. Anything that an accused could use to challenge the evidence and say that the evidence is not in its original form. What's also significant and important is that if there's an investigation and the South African Police Service decides not to prosecute, the investigators are obliged by law to dispose of any article. Now, article could, as I say, be a disk, it could be a laptop, it could also be a password. So they have to permanently dispose of that to ensure that your privacy is not infringed. The last point I just want to touch on is that the SAPS has to set up something called a designated point of contact, which is a central, highly skilled office that anybody, be it the public, be it people in other jurisdictions who need assistance with crimes that might have been committed here, that designated point of contact is your first port of call, and it has a number of responsibilities, including giving preliminary advice, facilitating cooperation with different jurisdictions, and a whole lot of other responsibilities. I don't think it's been set up yet. If it is set up properly with highly skilled police, then I think we will be able to boast about being able to manage cybercrime, and hopefully we get a lot more investment in our information economy. Thank you so much for putting up with my lack of cyber skills at the beginning. Fortunately, I managed to get my second screen working. And on that note, do we have any questions? And if so, please shoot.
Thank you. Thank you. That was very informative, very interesting. We have two questions. I don't know, hopefully we'll have time to get through them. Well, there's three now. But maybe if you don't have to go into too much detail. The first one is from Myla that says, does the regulator have a plan in terms of when they will commence with their on-sites?
Okay, I like that question. Now, remember, there isn't a schedule that the regulator is following. It can, of its own accord, just decide to pitch up and check whether you are complying or not. And it could well be that somebody whispers in their ear, it might be one of your competitors that says, hey, did you know? And they would then pitch up. But there isn't a schedule, as far as I'm aware, where the information regulator is going to start with the auditing sector, then the legal sector, then et cetera, et cetera, et cetera. So it literally could be ad hoc or random that this occurs.
Okay, great. On to the next one from Alyssa. In your opinion and experience, how long will it take for an organization to become POPIA compliant? I'm sure the first part of your answer would probably be depend on the size of the organization.
Yeah, absolutely. Look, Alyssa, we spent almost 2 years, and this was before POPIA became effective, assisting a major state IT-focused organization getting ready. It has about 4,000 employees. And at that point in time, the reality was that not many organizations had been through the process. When I say had been through the process, I'm talking about the people who are assisting the client to implement. So we called on best practice. We called on affiliate firms abroad to give us some assistance. That took about 2 years to get them fully compliant. And as time has gone by, it's become a lot more streamlined. We, for example, are now assisting a government department from scratch, literally from the gap analysis phase right through to implementation. And that we've we've estimated from our project plan 8 months. And that is not such a big organization, but I would expect it depends on the size of the organization, firstly. And secondly, I think that if you're using somebody who knows what they're doing, it can happen even more quickly.
Okay, great. Last one. I know we're 2 minutes over, but there's only this last question left from Mile again. Will cyber crimes be investigated only by SAP, or can the information regulator investigate?
I think there's the possibility of a dual process being occurring. The information regulator will investigate from a privacy perspective. In other words, where somebody's privacy rights have been infringed. And as I mentioned, there could be administrative fines and also civil liability. SAPS will investigate from a criminal law perspective. So nothing stops the information regulator from referring a breach and non-compliance with POPIA to SAPS. And SAPS will then investigate and charge you, one, with contravening certain sections of POPIA. And if you're the hacker, then certainly under the Cybercrimes Act, you will be liable for prosecution as well.
Okay. Thank you. That was very interesting, very informative, as I said earlier. We are now 3 minutes over, past time. Yeah, I think, we'll just wrap it up now, and I'll thank you all for attending. We do have another session next week, as I said at the start of this one, that we're having one session every week. The next one is called Meet the Hacker. So obviously there'll be some more, I don't want to say technical, but stuff around hacking and that sort of thing when we have the next session. But no, thank you very much, Lucian. And thank you to all that attended for this first part of our Black Swan series.
Welcome. Take care, everyone. Bye-bye.
Cheers, everyone. Bye.